Next, we're going to discuss some of the language and how the Second Amendment is worded exactly. The Second Amendment specifically states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The prefatory clause in that, which establishes the reasoning behind the creation of the amendment, contains two components: well-regulated militia and security of a free state, while the operative clause is the right of the people to keep and bear arms. The first part in the individual language that we're going to look at is the right of the people. The courts have been wondering, and as you saw when you first went over it, initially it was interpreted in a collective manner, now it's interpreted in an individual manner. But that was always a question. Which manner is it interpreted at? Collective, individual. The Heller decision, it applies in the individual manner. Justice Scala and the other justices all reviewed other circumstances within the Constitution where right of the people was used. When doing this, they found it in the 4th and the 14th Amendments. Based on their interpretations of how those interpretations were made, it led to this determination that it should be interpreted at an individual level instead of the collective. Next, we're going to review the ideas of to keep and bear arms. Arms. It has a meaning that hasn't changed since 1791. And that is that it's anything that a man wears for his defense or takes into his hands or uses in wrath to cast at or strike another. And it is also used for weapons that are in common usage. Common usage. And only those that are used by law-abiding citizens for lawful purposes. Based on that, you wouldn't expect a civilian to lawfully go and use an AR-15, which is an assault rifle. To keep. The idea of to keep just means to have arms, that you have them, that you own them. And based on our determination that we've made earlier, it applies in an individual manner. But then there's also the idea that the constitutional restrictions that have been placed on gun control in one's home that really you have to answer. You know, yes, restrictions are in place, but what does that mean to you individually? To bear. Simply, it means to carry the weapons, to have them on you. And it refers to that right to wear, bear, carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive actions in the case of conflict with another person. Justice Stevens, however, dissented on this idea and interpreted that the right to keep and bear arms only applies to the military. That's it. Now, when looking at the right to keep and bear arms, you also need to look at the right not to keep and bear arms. And that's our next topic. There are such things as choice rights. And it's the idea that some things you have a right to do, and you also have a right not to do. Perfect example for this, the First Amendment. You have the right to religion, you have the right freedom of speech, you have the freedom of press, freedom of assembly, but you also have the right to avoid those. Not to say anything, not to assemble, not to, join a rally. But there's also some gun control laws that really leave you questioning about if that right not to exists. The biggest one of these is the mandatory possession laws. But you also have concealed carry laws and any other law that prohibits the banning of weapons from one's property. Mandatory possession laws. As I said, this is one of the ones that I believe to be one of the most prevalent in this idea of the right not to have something. And basically, it's exactly what it says. It's a law that mandates that everybody has to have firearms and ammunition. And they're present in different states across the United States. It's present in Georgia, Idaho, Pennsylvania, Kansas, Utah, South Dakota. However, there is an exception to this. And that's the same rule that is across the country. And that's mentally ill and those that have been convicted of felonies cannot have this. Do not have to have a weapon. There's arguments on both sides. The pro, those that are for it believe that the widespread gun control, or the gun population, would deter crime from occurring. The con, however, they believe that it's unconstitutional because they require people to keep and bear arms whether they want to, whether they believe in that they have to have them. But some people honestly believe that the best self-defense is, I'm not going to have one. So, another one of these laws that really has to have you questioning that right not to keep and bear arms is the idea of concealed carry laws. Because they add a degree of difficulty to monitoring what's coming in on your property, what do you have? And this I found interesting, that many states actually mandate that unless they have a criminal record or mental illness, you have to issue them a concealed carry permit if they request one. And the guidance is that these laws are necessary for self-defense. That they have to be able to have them. I don't know. I question that a little bit. And then other laws that prohibit the exclusion of firearms. These are take your gun to work laws, parking lot laws, forced entry. And these laws in particular relate more to businesses than they do an individual. But now it's raising another point on, do the protections of the Second Amendment apply to the businesses and not just individuals. And this was a question that was not answered in Heller or McDonald. And an interesting tidbit that I found to be very important was that many businesses that allow firearms on their property have a 5 times higher chance of a homicide occurring on their property. I thought that was unique. At this time, are there any questions? That's all I have. Thank you.